Limitation of freedom of speech in Malaysia. What is freedom of speech? Freedom of speech is fundamental principle of democratic societies. In Malaysia, freedom of speech is a guarantee right under Article 10(1) of Federal Constitution. However, this right is not absolute and it is subject to various legal limitations which is clearly enriched under Article 10(2) of Federal Constitution. It allows Parliament to impose restrictions on free speech, if necessary. Enacted in 1948 during British to suppress the communist insurgency. After independence, the law remained as existing law, and continued through the formation of Malaysia in 1963. After May 13th incident, the racial riots led over 200 deaths. In response, government amended the constitution in 1971, which protected Malay rights, monarchy and citizenship law. It allowed Parliament to limit speech these topics even for MPs. The purpose is to protect the social contract. Non-Malays got citizenship, Malays got citizenship, Muslims special rights. Restricts freedom of speech deemed seditious, that promotes hatred or civil disobedience against the government or stirs hostility between races.
So it tells you a lot. It tells you a lot when we take time to stand in a public space.
Targets speech that questions sensitive parts of the Constitution such as Article 153 of FC, special rights of the Bumi Putera and other aspects of the Malaysian social contract.
Yeah, yeah.
Section 3 of the Act defines the meaning of seditious tendency, which is based on English common law but adapted to local context. Controversies criticized for being broad and vague and raises concerns about suppressing legitimate criticism and free speech. Section 3(1) defines seditious tendency as acts that incite hatred or disaffection against rulers' government, promote ill will between races, challenge protected matters, for example Art. 152, 153, 181. Section 3(2). Exceptions. Lawful criticism or calls for change, except on sensitive, constitutional matters where no exceptions apply. Section 3(3). Intent is irrelevant sedition judged solely by affect tendency, criticized for violating mens rea criminal intent standard. Penalty, up to 3 years imprisonment or Rm 5000 fine or both. Human rights criticism, restrictions judged only by Parliament's opinion, not objective necessity. Section 4(1) criminalizes acts, speech, publication with seditious tendency, even attempt or conspiracy, possessing seditious material equals offense.
This is the case that tested freedom of speech in Malaysia. In 2014, a storm of controversy swirled through Malaysia's legal and political landscape. Meet Dr. Azmi Sharome, a respected law professor at the University of Malaya. Known for his outspoken views and deep understanding of constitutional law, Dr. Azmi often voiced his thoughts on current affairs, especially issues involving democracy and justice. On the 14th of August 2014, an article was published by the Malay Mail online. In this article, Dr. Azmi commented on an unfolding political situation in Selangor, where he drew parallels to the 2009 Perak constitutional crisis. The comments included,
"What happened in Perak was legally wrong. You don't want a repeat of that, where a secret meeting took place. The best thing to do is to do it as legally and transparently as possible."
Those few lines would ignite a legal fire. Dr. Azmi was charged under Section 4(1)(b) and Section 4(1)(c) of the Sedition Act 1948. The government claimed that his words could incite hatred or dissatisfaction against the government or the administration of justice, but Azmi stood firm. He believed in academic freedom and the right to express legal opinions, especially on matters that affect the country's democracy. His legal team argued that the Sedition Act, which is a colonial-era law, was outdated and violated his constitutional right to freedom of speech. Under Article 10(1)(a) of the Federal Constitution, they brought the challenge to the Federal Court, Malaysia's highest court, questioning whether the Sedition Act was even constitutional in the first place. This case was more than just about Dr. Azmi. It became a symbol of academic freedom, constitutional rights, and the limits of free speech in Malaysia. Dr. Azmi filed a constitutional reference to the Federal Court under Section 84 of the Courts of Judicature Act 1964, raising two legal challenges. First, is Section 4(1) of the Sedition Act inconsistent with Article 10(2)(a)? Second, is the Sedition Act as a pre-medical law still valid under the Constitution? Ultimately, according to the Federal Court's ruling, the Sedition Act was ruled constitutional. In addition, Section 4(1) is a valid restriction under Article 10(2) of the Federal Constitution and is intended to preserve public order. Other than that, colonial-era laws are still valid under Article 162 unless repealed. The Federal Court made two key rulings in Dr. Azmi Sharam's case. First, on whether Section 4(1) of the Sedition Act is consistent with Article 10(2)(a) of the Federal Constitution. The Court held that Parliament has full discretion to decide what restrictions are necessary for public order. It is not the Court's role to judge whether a law is reasonable, only whether it fits within the constitutional grounds. Since Section 4(1) falls under those permitted grounds, Azmi's challenge was dismissed, and the case was sent back to the High Court for trial, although later, the prosecution chose not to proceed. Second, on whether the Sedition Act is still valid, even though it is a pre-medica colonial law, the Court referred to Article 162 of the Federal Constitution, which protects existing laws after independence, so long as they are modified to be consistent with the Constitution. As a result, the Sedition Act remains valid unless and until Parliament amends or repeals it. These rulings confirmed the continued power of the Sedition Act and raised bigger questions about the balance between national security and freedom of speech.
PPV, Wikisek and Ors 1971. Facts. Dr. Wikisek accused no. 1 was charged under Section 4(1)(b) of the Sedition Act 1948. He delivered a speech at a DAP dinner that allegedly contained seditious statements. The speech criticized government policies, raised racial concerns, and touched on sensitive national issues. Accused no. Tufan Yutang was the editor and publisher of the DAP publication, The Rocket. He was charged under Section 4(1)(c) for publishing Dr. Lee's speech in the magazine. Accused no. 3 and for Koksen and Lee Tekchi were the proprietors and printers of The Rocket. They were also charged under Section 4(1)(c) for printing the publication containing the speech. The speech alleged ethnic discrimination and criticized national policies. Authorities considered the speech seditious due to its potential to incite discontent and disturb public order.
The legal issues was whether the speech and its publication and printing amounted to sedition, whether intention to incite violence, disorder is a necessary element of sedition, whether freedom of speech could justify the content of the speech under Article 10 of the Federal Constitution. The Court held that seditious tendency does not require intention. Section 3(3) of the Sedition Act. The Court emphasized that mens rea, intention, is not necessary to prove a sedition, OFFENCE. Section 3(3) of the Sedition Act states that even if a person did not intend to cause a seditious outcome, they can still be guilty if the words used had a seditious tendency. In this case, Dr. Wikisek speech was found to have a seditious tendency under Section 3(1) because it criticized government policies, alleged ethnic bias, and touched on racially sensitive issues. Since the speech had the potential to incite racial ill will or hostility, the Court found that this alone satisfied the offense, regardless of the accused's intention. 2. Publication and printing also offenses. Section 4(1)(c). Fan Yutang as editor-publisher, and Koksan and Lee Tekchi as proprietors, were charged for publishing and printing the speech in the Rocket ... under Section 4(1). It is an offense to publish or reproduce seditious material ... by printing and distributing the speech. They facilitated the spread of content that had a seditious tendency, and thus were held liable. Legal principle applied. The accused may have argued that they were exercising their freedom of speech under Article 10(1)(a) of the Federal Constitution. Article 10(2)(a) allows Parliament to restrict speech if necessary for reasons like public order, national security, or morality. The Court applied this provision and ruled that, although freedom of expression is guaranteed, it is subject to lawful restrictions. In this case, since the speech could potentially create ethnic discord, the restriction under the Sedition Act was valid.
This is the case of Lim Guan Eng versus the public prosecutor, a story that sparked national debate on justice, freedom of expression, and political accountability. In the early 1990s, a 15-year-old girl accused powerful individuals of rape. Shockingly, no charges were brought forward, and the victim herself was detained. Lim Guan Eng, then an opposition member of parliament, spoke out fiercely. His publications accused authorities of protecting the powerful and ignoring justice. Lim was subsequently charged with sedition and publishing false news. The law under which he was accused criminalizes speech deemed seditious, including criticism of the government or judiciary. During his trial in Sessions Court between 1994 and 1997, the prosecution argued that his words incited public unrest. Lim's defense asserted that he acted in the public interest and fulfilled his duties as an MP. In 1997, he was found guilty and sentenced to 18 months in prison. His appeal failed, leading to the loss of his parliamentary seat and a subsequent 5-year disqualification from office. Rights groups condemned the conviction as political persecution. The public outcry reignited calls to reform sedition laws and protect political dissent. This case remains a stark reminder of the delicate balance between maintaining social order and preserving freedom of speech. Was justice served, or was dissent silenced? That question continues to resonate today.
The Sedition Act 1948 is a controversial law from the colonial era, still used today to restrict speech seen as a threat to national security or public order, intended to maintain harmony. In Malaysia's multi-ethnic society, often criticized for suppressing freedom of expression, seen as inconsistent with Article 10 of the Federal Constitution, challenges include vague and broad definitions of seditious speech, lack of judicial safeguards, fear of punishment causing self-censorship. Many call for the act to be reformed or repealed in favor of laws that balance security and civil liberties.